Madam Clerk, will you call the next case, please?
David Caldwell et al. Versus Ruby Falls LLC.
Is this the day to pick on Judge Marie Williams? Thank you, both. I know, Gary. I know. Okay. For the appellant.
Yes, Your Honor. My name is Lance Pope. I'm from the Hamilton County Bar. I'd like to reserve 3 minutes for rebuttal argument.
You may do so.
Your Honor, as I indicated, my name is Lance Pope, and I, along with my law partner, Richard Shulman, represent the appellant here, David and Nancy Caldwell. Just as a quick moment of professional indulgence, Your Honor. Your Honors, this is my first time to appear before the Court of Appeals, so thank you for having me. I look forward to the argument today. I want to take just a few moments and discuss a little bit about the facts of the case. This was a personal injury case where David and Nancy Caldwell on July 23rd of 2018 traveled to Ruby Falls. They met their son, their daughter-in-law, and several of their grandchildren there. The Caldwells had never been to Ruby Falls, and I don't know if Your Honors have or not, but it's a famous tourist attraction in Chattanooga. It's a cavern. You go to the top area, kind of a waiting room with a gift shop, and then you get into an elevator, go down into the cavern, and then follow the pathway of the cavern out to an underground waterfall. It's referred to as Ruby Falls. It's sort of the culmination of the tour. The waterfall is illuminated, and then the guests turn around and travel outbound back to the elevator, up the elevator, back to the area, and then leave the attraction. And this is exactly what happened on July 23rd, 2018. Mr. Caldwell and his wife and family arrived. They went down into the cavern and received some preliminary instructions from their tour guide, Russell Snyder. Mr. Snyder advised the Caldwells that as they were heading inbound, and this gets confusing, inbound towards the falls as opposed to outbound toward the elevator, but as they were heading inbound, they were to yield to outbound groups heading away from the falls. The Caldwells did that as they moved toward falls. They did in fact yield to other outbound tours. When the Caldwells got to the falls, Nancy Caldwell said it took a breath away how many people were there inside of the attraction, and they really began to realize how many people were packed into the cavern. They saw the falls and then turned around and headed outbound back to the elevator, and this is where things went awry. Their assigned tour guide, Russell Snyder, did not keep the group together as they left the falls. The Caldwell's tour group was allowed to string out quite a bit. Ruby Falls has a procedure by which they check on the caboose. They ask if they're still back there, and that's an effort to keep the entire tour group together. Well, Mr. Snyder didn't do that. By the time the Caldwells made it to the mirror pool area, there was a group, an inbound group, yielding against the wrong side of the cavern. The Caldwell's tour guide had not instructed that inbound group where to yield correctly. The inbound group was against the right side of the cavern as Mr. Caldwell and his family made his way out. They were against a handrail. Mr. Caldwell moved through that area and felt what he said felt like a foot on his right shin, and he tripped and fell. He sustained serious injuries to his arm, broken humerus, and then his family helped him up. He began to make his way out of the attraction, made it back to the elevator where his tour guide already was.
Excuse me for interrupting, Counselor. You made reference to mirror pool. Was there some confusion or mistake with respect to where this injury occurred?
I'm not.
The location of it inside the cavern?
Yes, Your Honor. I'm not sure that there was any mistake. There was a incident report completed by Ruby Falls staff. The incident report asks the closest attraction that you can recall. On that incident report, Ruby Falls staff wrote the Hall of Dreams or Myrtle the Turtle area. That's the attraction just before the mirror pool as the guests are exiting the cavern. So to the extent that there was any confusion about that, those two sections of the attraction are very close together. And Ruby Falls staff certainly should have known that when someone is injured, they're not taking great precautions to identify exactly the attraction in the cavern that's right around them, and should have taken care to determine exactly where the fall occurred and then what section of the cavern was close to that. So to the extent that there was any confusion, that's the only confusion. And I think that there was some dispute about whether, in fact, Myrtle the turtle was ever reported, that attraction, Myrtle the turtle, whether that was ever reported to Ruby Falls staff. Ms. Caldwell indicated that she did not report that to the staff. Mr. Caldwell was injured. He underwent 3 surgeries over the next 2 years to repair his injuries. We tried the case to a jury for 4 days, and a Chattanooga jury found that Ruby Falls, in fact, owed a duty to the Caldwells, that they breached their duty to the Caldwells, but just did not find that that breach of duty, that negligence, resulted in Mr. Caldwell's injuries. And when you hear all of the proof in the case and you think about the testimony that came out, it's easy, I think, for the court to think, well, of course that's what the jury found. The jury heard that there was some other individual whose foot Mr. Caldwell tripped over, and that was the cause of Mr. Caldwell's injuries, not Ruby Falls negligence. But what happened in the case is that the trial judge prevented the plaintiffs from putting on evidence that would explain the facts that they did hear, and then also excluded other relevant evidence as to causation. And I want to talk about 3 of those things this afternoon. First, the trial judge prevented the Caldwells from putting on evidence of maximum capacity of the caverns, rebuttal evidence. Your Honor, in the lead up to the trial, there was conflicting evidence about the maximum capacity. Ruby Falls Executive Director Cara Van Brunt testified that there was no maximum capacity in her deposition. And Ruby Falls 32-year facilities manager said that there was in fact a maximum capacity, and it was 300. So we submitted a request for an admission and said, admit that you were in excess of the 300-person maximum capacity. Well, Ruby Falls, of course, denied that and said that there was no maximum capacity for the cavern, and that there was no entity that inspected to determine the maximum capacity. Get to the trial. Ms. Van Brunt testified that there was no maximum capacity. Bob White, the facilities manager, testified. He testified there was no maximum capacity. We cross-examined him about maximum capacity, and he said, right, well, when I said 300 in my deposition, I just guessed. So that's where the proof was at the conclusion of the plaintiff's evidence. Then Dallas Rucker testified at the trial, and at the conclusion of Dallas Rucker's testimony, testified as an expert on behalf of the defense. And he's an employee of the city of Chattanooga. And at the conclusion of his testimony, one of the jurors asked a question of Mr. Rucker, passed the question to the trial judge, and Mr. Rucker answered the question from the jury about who determines the maximum capacity at Ruby Falls. Dallas Rucker testified that the fire marshal would do that. The fire marshal would determine maximum capacity. That, of course, had not come up at any point in the trial. And that answer from Ruby Falls' witness was in direct contradiction to deposition testimony and the responses to the request for admission. And we sought at that time to introduce that Ruby Falls took the position that the fire marshal, in fact, did not determine maximum capacity. Had never done that. That they took the position that there was no maximum capacity. The trial judge prevented us from putting on that rebuttal evidence and cited that it would just be cumulative. But that's not the law in the state of Tennessee, Your Honor. The law in the state of Tennessee is that if there's any competent evidence that explains or is a direct reply or contradiction to material evidence introduced by the adverse party, it's inherently admissible in rebuttal. Here, Ruby Falls' expert witness testified that the fire marshal would determine the maximum capacity. That was not Ruby Falls' position. It just simply was not. It's the first time it come up throughout the course of the trial. It came up in response to a juror's question, so clearly it was something the jury wanted to know about. We had evidence that was a direct rebuttal to that, and we were not allowed to put it on. That left the jury with the belief, a couple of things erroneously. One, that there was a maximum capacity. Two, that we had put on no proof about it, and so they were prevented from knowing whether the excess number of guests in the cavern could have potentially caused Mr. Caldwell's injuries. The second thing that occurred that prejudiced and was a mistake that likely would have affected the outcome of the trial is the trial judge prevented us from putting on evidence the details of a similar prior accident at Ruby Falls. We had an incident report from 2015 where another patron fell at the Mirror Pool area, tripped and fell, headed outbound at the Mirror Pool area. That patron was going the same direction as our client, Mr. Caldwell. Following that trip and fall, the executive director of Ruby Falls requested that there be some repairs to the Mirror Pool area. Those repairs did not all occur. The only thing that occurred is one of the handrails that was essentially rotting away was replaced with a stainless steel handrail.
What evidence did the jury hear of that similar incident specifically?
Yes, Your Honor. There was a report of the prior incident. It's Exhibit Volume 1, Trial Exhibit 15. I actually have a copy of it here. And it's a redacted report. And the redactions make the report almost meaningless. That's page 1 of the redacted report. That's page 2 of the redacted.
So basically, they just learned that there was a previous accident.
That's right. They were not allowed to know that it was a trip and fall. They were not allowed to know anything about that person's injuries at all. Just that there was an accident that occurred by the Mirror Pool at the outbound ramp. Our whole case was about a trip and fall at the Mirror Pool. Our client fell. This lady fell at the same location. After that, Ruby Falls requested some modifications to that area of the Mirror Pool. They did not complete all of those modifications. We wanted to be able to put on proof that Ruby Falls had notice of a fall at the Mirror Pool area and that they had not taken the steps to appropriately ensure that as their guests made their way through that area, that they did not fall over one another, that they would not trip and become hurt. And since we couldn't put on proof of the prior incident, we could not put on proof of that causation. And the last point I want to talk about, Your Honors, is that we should have received an inference regarding the spoliation of video evidence. Ruby Falls has 11 cameras in the cavern. Ruby Falls staff testified that the day of this incident, they reviewed the cameras and had the knowledge to be able to save this footage. They did not save the footage. Instead, within 14 days, the footage rolled off. The footage would have shown the lead up to the fall, possibly the fall, and everything that occurred after the fall. That evidence would have been critical evidence, no way to replace it, and without having a negative inference that video would have been unfavorable to the defense, we were not allowed to establish causation in the case. Thank you.
Thank you. You have your rebuttal time. Yes, sir, Mr. Cooper.
Your Honor, I'm Gary Cooper from Chattanooga Bar as well. I will try to address briefly those three areas and then a little more, but with respect to the rebuttal evidence as reflected in our brief, at sidebar, counsel for the plaintiff appellant acknowledged that they had made a request through the Public Records Act to the City of Chattanooga and the Fire Department, Fire Marshal's office for any certificate of occupancy and were advised there was none. Ruby Falls, they got into that they called Ms. Van Brunt and, excuse me, and asked her, and in their case in chief, they went into questions of what is the maximum capacity. This wasn't rebuttal to anything, what they were offering. Ruby Falls had the position. There is no maximum capacity established. By the way, there was never any allegation in the complaint of any violation of fire department code or anything like that. But all Dallas Rucker said in response to the juror question was, the question was, who would set the maximum capacity? He said, that would be the fire marshal. He did not say, and the judge pointed this out at that same sidebar, he did not say the fire marshal did establish it. That was not an affirmative statement that he had in fact established it. So the rebuttal essentially was not rebuttal. What they wanted to offer as rebuttal wasn't rebuttal. They wanted to call Ms. Van Brunt back up also, I think, and ask her about it. But anyway, that's my point on that. Secondly, with regard to the prior incident, the redaction of that prior incident, that prior incident report was rife with hearsay, for one thing. It had attached to it a witness statement that was redacted. That's the second page. It occurred 2 years and 9 months prior to Mr. Caldwell's fall. It recites that a lady, a patron, fell traveling outbound back toward or I guess inbound. I get confused, toward the elevators, the same direction Mr. Caldwell was going. The judge said, okay, I'm going to let that part of it in to show notice. And so it was redacted, and that part, the redacted, went in on the issue of notice. The nature of the injuries in the unredacted copy, which is in the record also, not before the jury, shows that there were different injuries, not the same injuries. It does not have, there are dissimilarities or potential dissimilarities. It doesn't have details about the condition of the pathway at the time, whether it was wet, what the conditions were, how many people were there. And it certainly didn't say somebody tripped this patron or this guest. So, put the whole thing into evidence, I think would have been an error. And I think a judge made that, trial judge made that assessment and said, okay, it's admissible on notice, but not on these other things. And we maintain that that was proper. I'll make this point. I'm digging a little here. This 2015 incident report, which occurred October 26, 2015. Mr. Caldwell's fall occurred July 23, 2018. Carla McRae, who prepared that 2015 incident report and who also prepared the 2018 incident report of Mr. Caldwell's fall, she authored both of those. Her deposition by video deposition was taken by agreement of the counsel prior to the trial and after plaintiff counsel had the unredacted report. They wanted to ask Ms. Van Brunt about this report as well, the 2015 report. Ms. Van Brunt had already testified. She didn't recall anything about the incident. The person to have been asked about it, if it were proper, would have been Ms. McRae, whom they deposed prior to trial and chose not to ask her about it. The dissimilarities, well, the lack of proof of similarities, I guess, in those two falls makes the judge's ruling and the exercise of her discretion in that respect reasonable. I would submit. Excuse me, I'm going to have to. Done that. All right, now, let's go to the spoliation issue, unless your honors have some question about those first two. A little history here. The plaintiff appellants filed a motion for spoliation sanctions early on in the case, fairly early on. And the trial judge considered that, the deposition testimony and the like. Factually, what occurred? Mr. and Ms. Caldwell came up from the cavern after the fall. Ms. McRae, Carla McRae, met them in the lobby. seeking to get information about, one, what happened, and two, where it happened. And there, as you can see, if you want to look at it in the incident report, it prompts those questions. She records that it happened near Myrtle the Turtle, which is a formation at the base of and on the Leaning Tower in the Hall of Dreams, which is a different area from the mirror pool. You know, this is not a straight line cavern, as you can well imagine. There are twists and turns. So they're not right next to each other, as perhaps counsel might have inadvertently wanted to lead you to believe. There's a distance. Yeah, that formation and the mirror pool are next in line to one another, but they're not right up against each other. But at any rate, the Caldwells said they denied telling her. They denied that Ms. McCrae even asked them where it occurred. They did not. They acknowledged, Ms. McCrae acknowledged, nobody ever mentioned the mirror pool to her. So, based on her conversations with them in trying to determine where this happened, she concluded it must have occurred somewhere near the Leaning Tower, Myrtle of Turtle, in the Hall of Dreams. She puts that on her incident report. After the Caldwells then go and drive themselves, or somebody drives them to the hospital, she then, Ms. McCrae, goes down into the cavern. Oh, one other thing. She testified, and Ms. Caldwell denied it, that Ms. Caldwell said it wasn't anybody's fault, he just tripped. There's a credibility issue there. Anyway, she goes down into the cavern, walks all the way back to Myrtle the Turtle, the Leaning Tower, the Hall of Dreams, and beyond, looking for something in the pathway that could have caused his fall, because given his wife's statement and what she had learned, she assumed we just had an accident here, a true accident. Not only that, she took 17 plus photographs of that. Then she comes back and she reviews video footage. There are like he said, 10 or 11 cameras throughout the cameras, and this is not like, this is a large cave. Then she comes back and she reviews footage of the camera near the Leaning Tower Hall of Dreams and sees nothing. Sees no fall, no commotion, no nothing, believing that she then concludes, well, he must have fallen somewhere on that part of the Hall of Dreams that's not covered by the camera footage, because the entire area is not. Just like none of the cameras can turn with turns and twists cover everything. So at any rate, so she doesn't save it. She doesn't save that. The suggestion here is, I believe, by the plaintiff attorney, if somebody falls in your cavern, and even if they tell you it wasn't anybody's fault, or here's a formation that I remember near the fall, that you're supposed to save every bit of video footage of every camera in the cavern. Here's what I think here. The judge denied the spoliation motion because of those conditions, and that it was not until the accident was July 23rd, 2018. October 21, 2019, was the first time, after suit had been filed on January 30th, 2019, the first time the mirror pool was ever mentioned or was ever suggested as a place of his fall. Not in discovery, not in the complaint, and not in their statements to Ms. McCrae. So, that expansive time afterwards, and these things routinely roll over after a couple of weeks. They basically they can be exported and saved, but if there's a reason to. but they weren't in this case. So that footage had been gone. It was gone long before we knew. To your Honor's question about was there some confusion about the location of the fall, I would suggest to you, yes, there was, particularly based on what we knew. So the trial judge went through the Tatham analysis and entered her order, in which she said that she did not feel that Ruby Falls' culpability was sufficient to warrant sanctions sought, and denied it. Now later, they submitted a request at trial for missing evidence instruction, they being the appellants, which we didn't have the evidence to not produce it, but so maybe that missing evidence charge shouldn't have been given. I didn't object to it. He gave the missing evidence charge, part of which allows, an inference of an adverse inference, but one of the key elements is unless there is a reasonable explanation. I think we just gave you the reasonable explanation of why it wasn't preserved. Okay, so I better hurry. Do you have any questions at this point? This case was tried on causation. There were credibility issues, as pointed out in our brief, and I won't belabor them here. Mr. Caldwell hedged a little bit on his condition of his legs. He testified he knew all these things. He knew it was winding and narrow. There are lots of people in there, and he needed to watch where he was stepping, and yet he testified that right before he fell, he was looking straight ahead. He believes somebody stuck a foot out, but he didn't see one. He doesn't really know what caused him to fall. On that basis alone, the jury have justified finding a lack of proof of causation. So, I think I've got a couple of seconds here. I won't get into, I had more. I guess there were credibility issues with respect to his wife as well with regard to the statement that they asked us to sign the incident report. There's no place to sign the incident report on the form.
Mr. Cooper, before you take a seat, I just
I'm sorry.
have a question. On the verdict, is this an inconsistent verdict?
I don't think it is, Your Honor. The case law, the law, black letter law, I guess, is negligence alone is nothing. I think there's to establish fault, not only you have to establish a breach of the duty, you have to establish that it was the actual cause of the injury. So in that respect, I don't think it's inconsistent at all. They just failed to meet the second part of their burden, or the jury concluded that it was caused by something else. I don't know. We don't know on what the negligence was the jury found, but it could have been, you had too many people in there. But it's not connected up to show that was causative of his fault.
Thank you very much, sir.
Thank you, Your Honor. Plaintiffs had their 4 days in court, and I respectfully submit that there's no basis on which this verdict should be set aside, and would respectfully ask that it be affirmed.
Yes, sir.
I just want to address some specific points Mr. Cooper made. First, Dallas Drucker testified that it would be the fire marshal that would set the maximum capacity. That was not Ruby Falls' position up to that point in time in the trial, in all of their discovery responses, in their depositions, or in the testimony. That was simply not the case. Mr. Rucker was wrong about that, and we had evidence in our possession to establish that that was not the case. We sought to introduce that so that the jury would not have the belief that the fire marshal set the maximum capacity and that Ruby Falls was somehow in compliance with that. We sought to introduce that a couple of different ways and were precluded from being able to do it. That prevented us from establishing that Ruby Falls exceeded any maximum capacity that they ever kept up with, the 300 person figure, or that based on their own records, that they had oversold tickets for the period of time that the Caldwells were in the cavern. The prior incident report that Mr. Cooper references is Trial Exhibit 15. I'd ask you just to look at it. It simply doesn't say that prior patron fell. It doesn't say that. It says outbound at ramp near Mirror Pool. We should have been allowed to introduce that this was in fact a fall at that location, that the person was walking outbound, and the report does say outbound, but that this person, this prior patron, fell the exact area where Mr. Caldwell fell and was injured, just like our client. We should have been able to introduce that so that the jury would know that Ruby Falls had notice of a problem at this area, and that it was their responsibility to make sure that the guests passed correctly in this area, that the inbound group wasn't yielding up against the handrail in a position that they would be able to have their foot in the way of another guest, causing someone to fall and break their shoulder, just like Mr. Caldwell did. And then finally, on the spoliation issue, Judge Frierson, you asked if there was some confusion. Because Ruby Falls was confused about where the fall occurred in the cavern, that doesn't excuse their obligation to preserve the relevant evidence. They have multiple cameras, I think at least 4 cameras, past the area of the Hall of Dreams or the Mirror Pool. Certainly, that video footage that existed the day of this fall would have captured Mr. Caldwell in an injured state leaving the cavern. There's no doubt about that. Their representative, their employees interviewed Mr. Caldwell when he came up to the elevator, to the main lobby. They saw that he was injured. Had they preserved that footage, there would have been relevant evidence that we would have had about Mr. Caldwell's injuries, and we could have presented those to the jury. There is no better evidence at trial than a video of what occurred. We did not have that to introduce because Ruby Falls did not maintain it. And a situation like that is not harmless in a case close, in a close case such as this. Thank you, Your Honors.
Thank you very much. I want to thank the attorneys for your presentation. And you should receive our opinion within a reasonable period of time. Mr. Cooper, let me ask you a question.